As you probably know, the European Union adopted a new regulation for the protection of crafts and industrial geographical indications in 2023. In November 2023, this new regulation entered into force, and now we are in the process of preparing the implementing regulation and delegated regulation with the procedural details. And the new system will enter into application at the end of 2025. So we still have more than a year of preparation until this new regulation will enter into application, and the first applications for crafts and industrial GIs can be submitted to the EU. For you to know, for us, the most important sectors that expressed interest for this kind of GI protection were the textile industry, the tapestry industry, but also clothes, footwear, headwear, leather articles, laces and embroidery, jewelry, watches and clocks, glassware, furniture, but also ceramics, pottery and porcelain producers showed interest for the protection as a geographical indication in the EU. Just to give you a few products, maybe you know them, that might qualify for protection in the EU. For instance, Baltic amber, or we have Murano glass, or Donegan tweed, or Solingen cutlery, or Puko knife from Finland, or Delft's blow from the Netherlands, but also we have Herent porcelain from Hungary, the Sonseca furnitures from Spain. So there are a lot of different product categories that could be potentially protected under our new regime. And I'm going to basically give you an overview how the protection system works in the EU. This new regulation has benefits for all parts of the society, but primarily it serves the economic interest of the producers that are actually manufacturing and contributing to the production or marketing of these products, because it boosts their businesses, since a geographical indication is a very strong marketing tool. It attracts the consumers. It increases the prices of the products because it shows that these products are quality products, which represent authenticity as well, and they express also the identity of these products. And a lot of producers pay particular attention to the identity of the products, and because of this, they are ready to pay more. What is also very important from the perspective of the producers is that they can count on ex officio enforcement action by the authorities, both offline and online. And with this, GI protection is obviously much stronger than pure trademark protection, where the right holder has to initiate any enforcement action in cases of infringement. It's also important that our GIs, once registered, can count on a greater protection at international level, because they can be included in the scope of trade agreements or other kind of international agreements, economic agreements, partnership agreements with third countries, and be protected directly through these agreements. And they can also rely on international protection through the Lisbon system, the Geneva Act. And with this, it's a very important protection, and going beyond the European Union. But also we see that the regions can benefit a lot in the EU from the protection of geographical indications, because not only the consumers are interested in GIs, but also the tourists. We prepared studies, and we understood that tourists like authenticity and authentic products, and they are even ready to go and visit the places where the production takes place. So we see that we can boost tourism by basically creating this system. And of course, tourism helps also in generating income for the locals. It's also important for the regions because the GI system helps retaining the workforce in the city or in the region where the production takes place, because we experience that some of these traditional methods are kind of disappearing, dying out, and it's very difficult to pass the traditional method and knowledge for the preparation of these products, and we need to encourage this. And the geographical indications do also this in a certain way, because making the products more attractive for the consumers, economically more successful, means that the producers will have more money to invest in teaching and passing on the knowledge to the new generations. And like this, we also contribute to the cultural heritage. So this traditional knowledge doesn't disappear completely from the market. Consumers obviously benefit from the GI system because the GI logo, the EU logo, increases their trust on the product quality and authenticity, and it helps them also in the selection. So all in all, since all these circles, all the stakeholders are benefiting from the system, we created the protection for crafts and industrial products, which was modeled after the already existing and very successful protection for agricultural and food GIs that we have in the EU. When it comes to the scope, I can tell you that basically we cover all kinds of craft and industrial products that are not which are not covered by agriculture, which are not agricultural products. So potentially any kind of product could be under the scope of our regulation, which is not protected under the currently existing agricultural regime. The type of product is going to be indicated always in the union register that we are creating for craft and industrial GIs. There are some borderline cases where we got a lot of questions from consumers and from other academics concerning where we will put certain products under the agricultural system, or rather our new system. For instance, these cases were the cochineal, essential oils, hides, skins, fur skins, cork, raw silk, wool, animal hair, raw cotton, carded, combed, raw flax, and raw hemp. And these products eventually were protected under the agricultural regime, not under our so-called CIGI regulation. The requirements for protection are the same as the requirements that you are familiar with in the area of agricultural products. So the product has to have a specific geographical origin, a place, a region, or country. It has to have a quality or reputation or other characteristics essentially attributable to the geographical origin. And at least one production step has to take place in the defined geographical area. So our regime, differently from the agriculture regime, only uses the concept of protected geographical indications. We didn't introduce the concept of protected denominations of origin, which means that in our case, even if a product is entirely produced in the region, so all the production steps are taking place in a certain region, it will still remain PGI, a protected geographical indication, and it will not be able to use a specific logo for what exists for agricultural products for protected denominations of origin. I'm going to also walk you through the registration procedure, with developing a lot, elaborating more on the procedure for third country applicants, since we are in Thailand, so I wanted to elaborate more on that. But first I start with the ordinary procedure, which has 2 stages. The ordinary procedure is designed for the EU member states and the EU producer groups, and it starts in the national phase with an application submitted by the producer group to the competent authority in the member state from where the product originates. So if the product is a French product, I mean, if the GI is a French GI, the application is submitted to the French competent authority, and the French competent authority will do the first examination, check whether the requirements are met for the protection, and if the French authority finds that the requirements for protection are met, the authority publishes the application for opposition, the national opposition, which means that only those can oppose the GI that are in France in this phase. And you know, the opposition can have different grounds. Someone can oppose an application based on the genericness of the name, that it's already generic, or because it's homonymous. But also it can be opposed because there is an earlier trademark with which the GI would conflict. And there are different grounds, and these can be checked by the national authority. But if all these grounds and examination and opposition procedure is over, then the national authority, in our example, from the French national authority, will take a decision. And if this decision is favorable, then the procedure continues in the union phase, in the union stage. And in the European Union, it is the European Union Intellectual Property Office in charge of the management of the GI system and managing the applications in the union phase. The European Union Intellectual Property Office, EUIPO, which is in Alicante, first scrutinizes the application, so checks whether the application is indeed in order, there are no manifest errors in the application, and if the EUIPO finds the application in order and complying with the requirements, publishes it for a worldwide opposition. So this is the opposition when also those, for instance, trademark producers, trademark owners can submit oppositions which live outside of France. So, for instance, in other European countries, or even outside of Europe. But if somebody from outside Europe want to oppose the GI, they have to show that the grounds for opposition are met in the territory of the Union. When it comes to and once the opposition procedure is over and everything is in order, the EUIPO is taking a final decision and on the registration of the geographical indication. If the geographical indication is registered, it is published in the Union Register, which is a publicly available database. Very similar. We are going to create a very similar Union Register to the one that already exists for agriculture products. Just for your information, we created a derogation also from the ordinary two-phase registration procedure, the so-called direct registration procedure, for those member states in the EU which have very, very few products that could potentially qualify for GIs. So for those member states, we decided to create a simplified procedure, basically, and we allow these member states to opt out from the ordinary procedure, which means that they don't have to set up a national authority and a national system for the first phase of the registration procedure. And in that case, the applicants from these countries can directly submit their applications to the European Intellectual Property Office in Alicante. The member states can apply for this derogation if they meet two conditions. The first condition is that they don't have a system at national level in place to manage CIGIs. This is the first condition they have to meet. The second is that they have to also show, for instance, through surveys or a study or market analysis, that there is a low national interest for CIGI protection in their country. But even if they decide to derogate, and even if the Commission eventually allows these member states, the European Commission has to approve these derogations. So even if the European Commission approves their derogation, they have to still appoint a national contact point that helps the EU IPO in assessing the applications. So for instance, if the EU IPO has a concrete question concerning a certain product from such member state, the IPO can contact this national contact point and request declarations and certain assistance. As I mentioned, the competent authority for crafts and industrial geographical indications is the EU IPO in Alicante. This is different from the agricultural system, where we have the European Commission in charge of the registrations and all the procedures. And when it comes to the Lisbon system and the Geneva Act, the EU IPO acts as the competent authority in the WIPO international registration system. This is because the EU IPO has the proven expertise and experience in examination and registration of different IP rights. You know probably that they are those that register. This is the authority that registers trademarks and designs as well, and they have also other competencies related to copyright. So they have really a very serious manpower and experience, and also they already help in the registration process for agricultural products, even if the European Commission is in charge for that. When it comes to the rights conferred by a GI, our regulation is very similar to the already existing agricultural regime. So a GI basically protects against any direct or indirect commercial use vis-a-vis comparable products that are not covered by the registration, that could exploit, dilute, or weaken the reputation of the GI, or which can be detrimental to the reputation of the GI. But also, a GI protects against misuse when the name is used in combination with style or other terms like type, method, or translation. Protects also against imitations and evocation, and any false and misleading information as to the origin on packaging or in advertising. But it's also important that under the EU regime, these GIs are protected also against goods in transit. So if there are goods transiting the EU and not meeting the product specification or seem to be counterfeited products, the right holder has the possibility to take action. And our regulation also included some provisions on misuse in domain names, because we experienced that sometimes GIs are misused as domain names, and this can be also economically detrimental for the GI producers, the GI producers, and this is why we decided to have these rules against abusive domain names. When it comes to the relationship between GIs and trademarks, our system is very similar to the AGRI regime. So if there is a well-known trademark or a trademark with reputation, and the GI name is identical or similar to this well-known trademark or trademark with reputation, then the proprietor of the trademark can block or prevent the registration of the GI. It can also happen that there is an earlier good faith trademark and then a subsequent GI application. In this case, most probably the EUIPO is going to arrange or ensure a coexistence between the earlier good faith trademark and the subsequent GI. And it can also happen that there is an earlier GI already registered, and later somebody comes trying to register a trademark, somebody who is not the owner of the GI. And in that case, the earlier GI obviously can prevent the registration of the trademark. But of course, it's needless to say, if you are a GI holder, it doesn't prevent you to also use trademarks on your GI together with your GI. And when it comes to protection of third country GIs in the EU, there are 3 avenues. So if Thai producers want to protect their products in the EU, they will have 3 alternatives, probably. The first alternative is applications submitted directly to the EUIPO. So a Thai producer group, which is already having a GI in Thailand, could potentially submit an application directly to the EUIPO. The second alternative is if there is a bilateral agreement or plurilateral trade agreement between the EU and the third country, then and the GI is added to the annex to these trade agreements, then of course the protection comes from the agreement itself, from the trade agreement itself. And as we know now, the EU and Thailand are negotiating a trade agreement, partnership agreement, and they are also discussing GIs. So this could potentially be also the future for some GIs, Thai GIs, being protected in the EU through the trade agreement with the EU. But of course, the negotiations are still ongoing, and this is the competence of DG Trade and the competent authorities for trade in Thailand. And the third alternative is the Lisbon Agreement, the Geneva Act. Of course, this is also an alternative if certain Thai products are protected. If Lisbon members, of course, it's available for Lisbon members, Lisbon member countries, but it's an important alternative as well for countries that are members of the Lisbon Agreement. And as I mentioned, the first and the most straightforward way to protect GIs in the EU is to submit an application to the EUIPO. Depending on the legislation in the third country, these applications can be submitted either by the producer group itself or by the competent authority of the third country. It depends on the legislation of the third country. We allowed in our system to both options, basically. It really depends on how the third country regulates this. We know countries which allow their producer groups to submit the applications directly, especially those where there is no GI system. For instance, US, we have some agriculture GIs, and the producer group applied. But of course, some countries prefer taking control of the GI and managing the application. For instance, Indonesia is a country like this. They prefer basically collecting the GIs that they want to protect in certain countries, and sometimes they take initiative and they submit the application for on behalf of the producer group, and this is also fine. The content of the applications, when directly filed to the EU IPO from third countries, are the following. So first, the product specification has to be prepared, and the product specification is the most relevant document for a geographical indication, because this is the document that contains all the relevant information that show that the name actually complies with the requirements for protection. It shows also all the control steps that were taken by the producers to ensure that the producers comply with the product specification. This is the document that explains also the whole method, the traditional method that is followed during the production, and the raw materials, if they are relevant for the quality or the special characteristics of the product, the packaging, if it really makes a difference, and if it has to really happen in that region, then it's also included in the product specification, and many other information. The single document is also important. The single document is a public document that summarizes basically the product specification, and this is the document that is even going to be translated to all EU languages and made public. The accompanying documentation is also important. For instance, it includes the contact details of the control body in the third country that verified the compliance with the product specification. And we also require a legal proof of protection of the GI in a third country. This protection doesn't have to be a GI protection. So if you have, of course, a GI system in your country, then of course this protection has to be presented to us. The legal proof has to be submitted. But in countries where there is no GI system, it can happen that they have a product that could potentially qualify according to the EU rules to a GI protection, and in that case we left our system open for these products, which actually qualify for GI protection, just they don't enjoy national protection because they didn't introduce a system for this. For instance, the US is a good example. They don't have a GI system, but they have some products that qualified according to our system to GI protection. And we need also a proof of power of attorney where the applicant is represented by an agent. When it comes to the protection through trade agreements, as I mentioned, it's another important avenue for a lot of products. Many products are protected through trade agreements concluded with the EU, and the EU is also protecting many of its products in certain countries through trade agreements. The good thing about trade agreements is that once they are concluded, the GIs under its scope enjoy direct protection. So the producers don't have to pay the fees and go through the registration procedure. They enjoy also some support by both trading partners in terms of enforcement. There is more attention on this. There is a lot of attention on these products because they are included. They are shortlisted in the trade agreements. Usually, they represent only a certain percentage of the of the products or of the names of the GIs that are actually protected in the union or in the trading partner. And what is also important is that once these GIs are protected through the trade agreement, there is also a decision about whether these products can or cannot use the EU GI logo. There is the possibility to enter these products in the union register, these third-country products in the union register. But this is not an automatic decision. This is always a decision taken by the European Commission in negotiation with the trading partner. Obviously, it depends on many different circumstances. The most important aspect is that that in these trade agreements we agree on the basic rules that has to be complied with by our trading partners. And if we consider the GI system of our trading partners equivalently high standard to our, then we can allow the use of the EU GI logo. But if we see that the requirements are not so strict, or if the enforcement is not so reliable in a third country, then we would rather not allow the use of the EU GI logo. And here I just wanted to mention that the European Commission is going to remain in charge of the negotiations of the trade agreements, also for craft and industrial GIs. So it's gonna be actually my unit in the Directorate General for Growth, and under, of course, the overall guidance and direction leadership of the Directorate General for Trade, if it's a trade negotiation. But the European Union Intellectual Property Office is going to assist the process. But I wanted to underline this because it's always important that in case you have any request, initiative concerning a trade agreement, you should always come to the Commission and not to the EU IPO, because the EU IPO is going to remain a registry office and support for the Commission. But the negotiations are going to remain in the hands of the European Commission. When it comes to the protection via the Lisbon system and the Geneva Act, probably you know that this is an easier access to be protected in the EU. The regulation 2019/1753 regulates the main elements of the procedure. This procedure also includes an examination and an opposition. So it's not an automatic protection. And as I mentioned, the EU IPO is going to be the competent authority for CIGIs, and for agri products, it remains the European Commission. These GIs may be entered in the Union Register, but this is not an automatic decision, just like it is not the case for trade GIs protected through trade agreements. And GIs in the Union Register are entitled to use the EU GI logo. As I mentioned, probably it's interesting for you to know that we will also include, we lay down some provisions on a transitional registration procedure in the EU. Because in the EU we have already at national level many products protected by geographical indications, many names protected by geographical indications, and we wanted to ensure for these products a fast track procedure. So basically from the national system they can transfer their products under the EU system by going through a fast track procedure which will not include an opposition procedure. The most important is that the EU member states will have to inform the Commission and the EU IPO about the products, about the names that they want to transfer under the EU regime by a certain deadline. And if they do this, the EU IPO will do the usual check. So they will still check the products, the names, and whether they qualify for the GI protection. And if they qualify, they will register these products and enter them in the Union Register. And fees, I think the fees are also important and interesting. At national phase, the member states may charge fees, so we didn't regulate this. We left it open for member states to decide how much fee they want to introduce for the registration of GIs. Most member states have fees, and some higher fees, others a bit lower fees. It really depends on the country. You know also that there are big divergences in the EU in terms of salaries and everything. So considering this, we didn't want to introduce one fee across the member states because there are big differences between member states economically. But we introduced a clause which obliges the member states to take into account that the majority of the producers for crafts and industrial products are SMEs and family businesses, micro enterprises, and because of this, they have to have relatively moderate and lower fees. In the union phase, the EU IPO is not going to charge fees for if there was a national phase. However, the EU IPO will charge fees for the direct registration. So when and direct registration means that the registrations that come from member states or from third countries, because in this case, basically, we cannot ensure that there is a fee in the national phase. So at a certain point of time in the registration procedure, the producers have to pay a fee. And so in the direct registration procedures, there will be a fee. We don't know yet how much or what will be the fee level. We are working still on this, but there will be some fee in the direct registration procedures. And I wanted to also elaborate on the control enforcement regime, which is very important for crafts and industrial products as well. And this is the area where we deviated the most from the agricultural regime. Probably you know and you understand very well that the producers have to be controlled and checked to ensure that they comply with the product specification. We have to ensure that the products that use the GI logo and the GI name actually comply with the product specification, and this has to be controlled by some authorities. So we basically created two options for the member states. So member states can choose which control regime they want to introduce. The first alternative is the so-called third-party certification control regime, and this is the regime that currently exists for agricultural products in the EU. And this regime is basically based on a competent authority or accredited product certification bodies, which are checking the compliance of the products with the product specification. These authorities are checking the compliance with the product specification before the product is placed on the market. This is the so-called verification. But also, once the product is on the market, it has to be monitored. And this is also done by these competent authorities and often on the basis of risk analysis. The control authorities have multiple competencies. They can do on-the-spot checks, do risk analysis, and request documents, go on the spot, and take different control and enforcement actions. But in the EU, we also provided for another alternative for the member states, which want to opt for this second alternative. And this alternative control regime is based on self-declaration. So under this regime, the producers have to declare the conformity of their products by submitting a self-declaration to the competent authority before the product is placed on the market. And also later, when the product is on the market, they have to renew this declaration every 3 years. This doesn't mean that the control authorities will not do checks. They still can do random checks. They can even do risk analysis if they want. So basically, they are authorized to do whatever control action they want to do, but they are supported by this self-declaration prepared by the producer group. The self-declaration is a very useful document because it will include basically all the control steps that has to take place, and basically it gives a lot of very important information where and how the producer group controls its producers to ensure that actually the quality and the required criteria in the product specification is actually met. Beyond this, the member states will also have to take action against the counterfeiting of GIs. Not surprisingly, it's very important because there are a lot of misuses, imitations, and of course counterfeiting. And member states will prevent and stop all kind of misuses in the EU, in their country. And the regulation that we introduced also laid down provisions on deterrent penalties in case of infringement. And maybe a few words about the next steps. As I mentioned, the new regulation will enter into force in December 2025. Now we are working on the implementing and delegated acts, which are going to basically lay down the details on the procedure, because I mean the procedure is already prepared and laid down in the main regulation, but there are certain details that have to be worked out in a secondary legislation. We are also preparing our communication and promotion campaign, and probably next time, once our system is up and running, we are going to be able to share with you more about our communication and promotion campaign, which is still at the moment is in a preliminary phase. What I can tell about it is that we are going to have a visual identity. We are creating a unique visual identity for craft and industrial products. So every communication on this front by the Commission and by the EU IPO, we use the same visual identity. Will be similar. All the leaflets, all the brochures, or the websites, everything will have some common features that will show that we are talking always about the same system. With this, we can potentially gain more visibility for our new system, because of course we have to ensure that the producers know about this system and they actually register their names for crafts and industrial products. We are also preparing for international negotiations. Our goal is to also protect craft and industrial products through international agreements that the EU is negotiating with our trading partners. And we are also working very closely with the producer groups and the regions. We are working mostly on the marketing with the regions, so that they also contribute to market and promote the new GI regime as an opportunity for the producer groups. And we also work with the producer groups and the different sectors that represent a lot of producers that can be potentially interested in the new system. And of course, they are mostly involved in the marketing of our new regime. And I think with this, I concluded my presentation. I exhausted my time, I see, but I am still happy to answer any questions that you might have.